Good morning, everyone. Feel like a teacher. I'm Karen Cage. I'm the CEO for Realcomp. And welcome to all of you to our very first MLS Updates and Educational Forum. It literally took us 2 days to come up with the name for this event. I'm not exaggerating. It took that long because we just didn't know what we wanted to call it. And we wanted to make sure that you understood exactly what was going to be happening here today. We're so pleased that so many of you took time out of your schedule to be here today. We had over 400 people register, and I'm just so grateful that you would find this important enough to, again, take time out of your schedule to be here. We're confident that you will walk away today having learned new information that will be helpful to you in your business. So it's been quite a year so far. I'm sure you would all agree with that. A lot of changes. And these are changes that you all had to make in your day-to-day business, not just things that might happen or could happen. They happened, and you had to change a lot of the way you do business every day. I have to say that you've done a really good job of embracing the changes, even though I am confident many of you didn't like the changes. I get it. We didn't like them either. But you've done such a great job of adapting to them. We are an example for all of the other boards and MLSs around us who say to us, oh, we didn't think about having to do that, or we didn't add that check or balance or those data checks to our listings. And so we've been trying to help as much as we can, but you've all been such a great example of how you can make it work. Like many of you, I have been in this business for many years. I was 5 when I started. We've endured a lot of changes and challenges together. I've known so many of you for many, many years. I was talking to somebody out there who said, I feel like I'm 13 still. And I said, me too. And again, some of these changes are harder than others, but this most recent round of things you had to do differently, certainly I think have been the most dramatic and probably the most difficult. But here we are. So today, first this morning, you're going to hear an update on the recent NAR settlement from Realcomp's attorney, Brian O'Keefe, sitting right down here in front. I'll introduce him in a minute with his trusty sidekick, Noah. Welcome, Noah. It's my first time meeting Noah. We're going to break him in, get him used to what we do. He's going to talk to you about how we got here and how we adopted the changes necessary to remain compliant with the new rules. He's going to take you on a look back a little bit about how this whole thing started. And if you weren't able to sit through one of our previous webinars, I think it'll give you a better understanding. Again, not that you'll say, oh, okay, that's good, but at least it will help you understand how we got here. And then we're going to leave time for your questions. We have about 15 minutes if we stay on schedule. If we don't get to all of your questions, not to worry. Brian has agreed to hang around all day. And he's got a table outside, and he'll be available to answer your questions. As we go through this first presentation, if you could wait until we're done to ask your questions, I would appreciate that. And then again, if we don't have time, we do have to keep to a schedule. For those of you who know Fran Green, our marketing manager down here, she's got a hook, and she'll pull us off the stage to get ready for the next presentation. So, but we will make sure that everybody gets the information you want and that he can answer all of your questions. But before we begin that, I want to talk a little bit about what we're seeing in the market today. Our most recent statistics, and that would be for September, they're really encouraging. And it's so nice to be able to stand here and give you what I see as some good news, some positive news. We have more inventory available, and that's partially because sales are down a little bit. But I think the best part is the number of new listings being submitted is up close to 5%. And that is a really positive stat to see more people confident that this is the time to get their house on the market, and they're taking advantage of that. And so we're seeing more listings coming in. One of the questions I get asked when those stats are published is, what does it mean when the days on market increases? Used to be property took 30 days to sell, and maybe now it's 33. Now I see the positive in that too, because with more inventory, more properties available to your buyers, they can take more time to look around, find exactly what they want. And again, I see that as a positive. And that's the message that we try hard to communicate to the media when they ask the questions. I don't have to tell you that a lot of times the media is looking for the, oh no, the Eeyore approach to real estate, but that's not what we're about. We see the positive, and we're able to point that out to them, and hopefully that's what they publish. And that's the message that they send out to keep encouraging people that are interested in buying and selling to contact you. More properties on the market, again, means more time to make the right decision. Now, the prices are remaining steady. In fact, they're up a little bit. They continue to rise a little bit each month. And that may or may not change as the inventory rises. We're going to keep a really close eye on that. We do publish these stats every month. Hopefully you'll be able to take a look at them. If ever you're wondering what some of the numbers might represent, absolutely reach out to us. We're happy to talk to you about those and how we generate those numbers and where exactly we communicate that information. We have a lot of media sources that we send those stats to, and hopefully they'll contact us and say, tell us more. That's our goal. Also today, you're going to have an opportunity to see a close-up presentation of some new AI features that are available through a program called Lundy. AI seems to be, that's the phrase of the year. You can't watch any news or any program without hearing about AI this. And so Lundy, we introduced it to you a couple of months ago, and it's a program that allows you to, and your clients, to search for properties by using, if I say this and your device goes off, I'll apologize right now, by using Alexa. It happens to me all the time when I'm talking about it. And they're looking at adding more devices as well, so that you'll be able to use Google or Siri. They're working on that right now. This company is a brand new company to the market, very, very smart, very in tune with, again, with what's available through AI. When it was first released, you could use it by opening the device, saying, open Finding Homes. And if it opens up on your device, again, I'm sorry. And you could say, I want to see houses in Troy with 3 bedrooms, 2 baths. And it would come up and show you those properties, especially if you had the device that shows the photos. But now it got almost scary good, because now you can say, when those listings come up, you can say, show me the ones with a finished basement. So it will narrow the search to show the finished basement. And then you can say, show me the finished basement. And any of those listings that has a photo of the finished basement, you will see that photo appear. And it goes much, much deeper than that. If you have an Alexa device, you should play with it and see. In fact, they just introduced, it now works in Spanish as well. I don't speak Spanish, so I can't test it for you, but Janine's going to show you that later today. Now, I've had some agents ask me, well, how does this help me? How does this program help me? It's the same thing, but a little more convenient to having your customers search on websites. Only now they can do it by speaking to the device and searching that way. So when they come to you and say, I've been looking around and I see there's this house, and this house I'd like to go see, they've been able to have that information provided to them from this device. See, I talked about 15 minutes not being very long, and now I have to hurry. One other thing, if you're driving your client around, and you're going to view houses and you have your buyer agency agreement with you, all signed, ready to go. And maybe you're going to a specific home, but they look over here and say, hey, what about that one? There's a for sale sign. What about that one? And in your car, you right now have an Alexa. You can speak open finding homes. You can speak in the address. It'll pop up and give you all the details for that property. And you'll be able to determine if your buyer is interested in looking at it or not. So there are a lot of advantages. They're coming out with new things all the time. Like I said, they're brand new. And just really smart young people that are way ahead of the curve in putting this stuff together. Realtors, so they understand your business. We'll have some training labs that you can attend over in room 101. Janine is over there. She'll walk you through some training. And you'll see lots of Realcomp people here in these blue shirts that can answer any of your questions. Some of them are from our support team. So if you've talked to Storm or Cheryl and you'd like to meet them, they'd love to meet you. So they're out in the lobby and available. So this day is jam-packed. And of course you get lunch, and we all want that. And I just want you to know just how grateful I am for your loyalty to Realcomp. 30 years. We've been doing this for 30 years, and I'm grateful for all of you. And I want you to know that I know how hard you work. I know your profession is not easy. And I have a lot of respect for what you do. And hopefully we show you that by what we can introduce to you and how we can help you day to day. So now I'm going to introduce Brian so I can stay on time. Okay. Move this here. Brian's got a lot. Brian O'Keefe is a founding partner of Lippitt O'Keefe, PLLC, a Birmingham, Michigan-based law firm. He supervises the firm's transactional, real estate, business, and personal planning departments. And Brian has been serving Southeastern Michigan businesses and entrepreneurs and their families for almost 40 years. Brian is outside general counsel to Realcomp, the largest real estate multiple listing service in the state of Michigan. And over the course of his career, Brian has been legal counsel in transactions with a cumulative value in excess of $1 billion. Brian received his Bachelor of Arts degree from Michigan State University. He's in the right place today. He received his Juris Doctor degree from the Catholic University of America. Brian's professional memberships include the State Bar of Michigan, the Oakland County Bar Association, and the American Bar Association. Brian is a longtime philanthropist and has served on numerous community and company boards and committees, including the Manresa Retreat House and the Young Entrepreneurs Organization. Brian lives in Birmingham with his wife, Robin, and their 4 children. And I want to add, when Brian calls NAR and says, we have questions about these changes, they listen to him because he knows his stuff. And they tell him how grateful they are for the knowledge that he brings because he helps them. So I think you're going to get a lot of information out of this. If you haven't already seen it, maybe you'll pick up something different if you have. So Brian?
Thanks for the nice introduction, Karen. Welcome everyone. Good morning. How many of you have seen one of the webinars? Okay, so some of this is going to be repeat information, but I think there's still a lot to be learned, and it doesn't hurt to go over things, multiple times. One of the things you can probably ascertain from the introduction is that I'm old. I've been practicing since 1986, and I can recall when purchase agreements, both legal purchase agreements and purchase agreements that were done by realtors were done on typewriters. When we had mimeograph machines and Xerox machines. I'm sure some of you can remember those times. And in some ways, this is going back to that. By taking offers of compensation off the MLS, we've got to go back to some of those times when phone calls were made, when meetings were had. So let's look at some of this in the context of of that. And I think it will help make sense and help give some indication on how you can do business going forward. Without a good legal disclaimer, it's not a legal seminar, so let me read to you our legal disclaimer. Due to the nature of this presentation, please be advised of the following. The information disseminated during this presentation may not be exhaustive of the subjects covered during this class or of all the subjects which may impact the business of the attendees of this class. By disseminating information during this class, Lippitt O'Keefe and its agents are not inviting or establishing or intending to invite or establish any attorney-client relationship, principal-agent relationship, or any other legal or business relationship. The attorneys of Lippitt O'Keefe are licensed to practice law only in the state of Michigan, and nothing during this class shall be construed to constitute legal advice under the laws of any other jurisdiction. The attorneys at Lippitt O'Keefe are not accountants nor tax advisors, and nothing during this class shall constitute or be construed to constitute tax advice or a tax opinion. And by participating in this class, Lippitt O'Keefe and the participants of this class are not intending to coordinate the actions of competitors in violation of state or federal law, but are rather sharing information in an attempt to comply with applicable state and federal law. The last part is particularly important. The real estate industry and all of you are competitors, your colleagues, just like in the practice of law, we're colleagues, we're competitors, we're licensed professionals. And so anytime there's or appears to be a coordination of competitors, which there is through some of the rules that NAR and the Michigan Realtor boards have promulgated, whenever there appears to be a coordination of competitors, there is scrutiny by the Federal Trade Commission, scrutiny by the Justice Department. And the real estate industry has been under scrutiny since the 1950s, really, due to some of the rules that have been promulgated nationally. Before we get into the details of that, this is an outline of the agenda for today. I'm going to talk about the genesis of the Morrill and Sitzer cases. I'm going to talk about the nationwide settlement. I'm going to talk about practice changes that are required as a result of the settlement. We'll talk about the implementation and timing. Some of that has already occurred, of course, and someone asked me out in the lobby, what's new? Well, I want to know from you what's new because we've implemented a lot of the changes. They've been in effect for 60 days now. So I'm going to want to hear from you at the end here, maybe about what's new, and maybe that'll raise some questions. We'll talk about changes to the MLS system and the forms, and then we'll have, as I said, a Q&A. So the Sitzer and Morrill cases are the cases that brought all of this to fruition. The Sitzer lawsuit was brought against sellers in the state of Missouri in 2017, claiming that sellers of homes overpaid on commissions, and that the cooperative compensation rules that were promulgated by NAR were illegal and were resulting in those higher commissions. That was a case brought only in Missouri and only against the sellers of homes in Missouri. And that's an important point for you to remember when I get to some of the damages that we're going to be talking about. In 2019, the Morrill lawsuit was filed. That was filed in Illinois. And it basically raised the same issues that the NAR rules relating to cooperation and compensation were illegal, improper, were in violation of the antitrust laws, and were resulting in sellers paying commissions that were too high. During the same time, and really rose in 2020, the Federal Trade Commission and the Justice Department were also looking at NAR and reviewing carefully its rules, both the rules on cooperation and compensation, and then the clear cooperation policy that NAR put into place in 2020 resulted in a more detailed look by the Justice Department into these rules. In October of 2023, the Sitzer case went to trial, and the jury awarded the plaintiffs $5.36 billion. The jurors found that home seller plaintiffs had proved that a conspiracy existed and that the NAR policy known as the cooperative compensation rule was improper. The jury also found that the conspiracy had the purpose of affecting, raising, initiating, and stabilizing broker commissions that were paid by home sellers. Soon thereafter, almost immediately thereafter, there were dozens of copycat cases filed in jurisdictions around the country. It appeared overwhelming to the defendants, including NAR and a lot of the MLSs and large brokerages. Therefore, in March of 2024, the plaintiffs and NAR announced that there would be a settlement in which NAR and many of the MLSs that were named and brokerages and realtors were going to be settling the case, and there would be a sort of a global settlement across the country of these cases. So the settlement agreement was entered into in March, and it provided that it would resolve claims against NAR, all the local realtor associations, all association-owned MLSs, and all brokerage firms with principals who had realtors who were realtors and whose volume was $2 billion and below. The settlement amount was $418 million, and as you can tell, this was substantially below the $5 billion that was awarded in the Missouri case alone. If these cases had gone to trial, they would have overwhelmed the industry. They probably would have destroyed NAR. They probably would have destroyed a number of the large brokerages. They probably would have destroyed a lot of the local MLSs. So a settlement was really required. There was too much at risk to go forward. So the settlement agreement, as far as plaintiffs goes, covers all plaintiff home sellers in the United States from the period of approximately 2017 through the time of the settlement agreement of 2024. Any seller who has paid commissions will be able to opt into this class and receive a portion of the settlement related to there's a formula that will provide what a home seller will receive. The plaintiffs, the home sellers before 2017 are not covered, but those home sellers are probably not able to bring claims because of the statute of limitations. There were two particular types of entities that were not automatically covered. Brokerages with residential transaction volume over $2 billion. Some of you may be realtors in those large brokerages, and non-realtor MLSs. These entities were not automatically covered, but there was a procedure by which they could opt into the settlement, and most of them, if not all of them, have opted into the settlement. So what did the settlement involve? Realcomp is a released party under the settlement agreement. Realcomp does not have a monetary obligation to pay any money towards the settlement agreement. We were named in the lawsuit, but we were not sued for damages. We had to participate in discovery and turned over a lot of documentation, but we were not a defendant in the lawsuit. NAR members are covered individually. All of you are covered. Unless you're independent contractors or employees of Home Services of America, Home Services did not immediately settle with the plaintiffs. But since the time that we were originally giving these seminars, they have reached a settlement, and so now realtors with Home Services if there are any of you out there, you're covered as well. All of the brokerages are also covered, as I mentioned. You should check with your broker to see if there's questions about whether you're covered or not. Brokerages with over $2 billion in volume are not automatically covered, but as I said, most of those have opted into the settlement. So besides monetary damages, the settlement, as you all know, required changes to the way we do business. The first change and the most difficult change is that offers of compensation are now prohibited from the MLS. As such, all compensation fields were removed from Realcomp during the week of July 15th. And of course, All the other MLSs in the country that want to be covered by the settlement are having to make these same changes. So nationwide, there should be no offers of compensation on MLSs, particularly association-owned MLSs. Brokers and agents must now communicate offers of compensation via phone, email, in person, through their own websites. Still offer compensation over your website, but you can't do it through the MLS. To address the issue of agents posting offers of compensation in remarks, Realcomp ran cleanup protocols and continued to look for violative language. Most of that was caught early on, and we're seeing less and less of that, I think, Karen, right? And all of you are doing a good job. There was worry about, people using remarks to offer compensation. The plaintiff's lawyers were onto that very early on and have said to us, and Karen referenced my discussions with NAR. I do talk to NAR on almost a weekly basis. The plaintiff's lawyers obviously correspond mostly through NAR because NAR was the main defendant in these cases. So the plaintiff's lawyers made it very clear that they were going to watch for behavior that was trying to get around the rule that required no offers of compensation on the MLS. There were places to do it, like in remarks. They're probably watching. Maybe there's a plaintiff's lawyer out there in the audience. I'm not sure, but there are prohibitions against making offers of compensation in remarks. I think in internal to Realcomp, we've been very good about that, but it's something we just want to make sure that that you're aware of. Certain disclosures must also be made to prospective sellers and buyers. The most important of which is that broker compensation is not set by law and is fully negotiable. So we have prepared, and I'm going to get into this in some more detail, but we have prepared forms. There are Realcomp sanctioned forms, and we have made sure that in the Realcomp sanctioned forms that this is one of the clear statements in the seller agreements and in the buyer agreements. Broker compensation is not set by law and is fully negotiable. If you want to look at, get an up-to-date view of what's going on in the industry, you can go to facts.realtor, and that is the NAR sanctioned website that is keeping everyone up to date on the settlement, the ongoing discussions in other areas. There are still, I'm going to get into this a little more, but there are still a number of lawsuits pending. So if you want to see what's going on a day-to-day basis, you can go to facts.realtor. Some of the additional practice changes are as follows. MLS participants and subscribers must not represent that brokerage services to clients are free or are available at no cost to the client, home buyers or sellers. Unfortunately, there was findings during the lawsuits that a lot of buyers agents were saying my services are free to you, Mr. and Mrs. Buyer. And of course, in some ways that was true, particularly where a seller was paying the buyer broker commissions. But the FTC found, and the jury in the Sitzer case found that that was a deceptive trade practice, and that that should no longer be part of the industry's communication. A written agreement, and we're going to get into this in detail because this is very important. I'm sure that all of you may be struggling or having some questions with this, but a written agreement is now required for MLS participants acting for buyers. Again, we've prepared some documents that are meant to address this issue and that satisfy the settlement with regard to this issue. I'll get into that in a little more detail as well. In the listing agreement between the seller and the seller broker, the language required by the settlement agreement must be conspicuously displayed. And as I said, it has to say that brokerage commissions are not set by law and are fully negotiable. The MLS participants acting for sellers must conspicuously disclose to sellers and obtain seller approval for any payment made to another broker. The disclosure must be in writing, must be made in advance of payment, and must specify the amount of such payment. And again, this is one of the rules that I think people were struggling with, both in planning for how to do this and maybe now in the implementation of this. We'll talk about a document that we've prepared, but basically the requirement is that you have to tell your seller, you have to be very clear and in writing with your seller, if you're representing a seller, how the commission is being paid, who it's being paid to, and how it's being shared if there's a sharing arrangement going forward between the seller broker and the buyer broker. We've prepared documents, exclusive right to sell, an exclusive agency, and a co-broker compensation and cooperation agreement. So let's break down in a little more detail these requirements. The first, and this is right out of the settlement agreement, the multiple listing service shall not fix, control, recommend, suggest, or maintain commission rates or fees for services to be rendered by participants. Further, the multiple listing service shall not fix, control, recommend, suggest, or maintain the division of commissions or fees between cooperating participants or between participants and non-participants. And the reason I have this is this is sort of the fulcrum of the settlement agreement and the requirement that the MLS is adhered to. Really, and the settlement agreement did put a lot of pressure on Realcomp and all the other MLSs. The MLS is the policeman really to implement all of these changes. Since all of you are using the MLS as a system to list homes, list and buy and sell homes, the MLS was given the task, if you will, of making sure that this settlement was fully and properly implemented. So how do you go about doing business now? As a seller's agent, you need to have a written agreement with your seller. As a buyer's agent, you need to have a written agreement with your buyer. The agreements have to have certain language in them. As I said, brokerage commissions are not set by law and are freely negotiable. That's one of the main requirements of these agreements. When you're dealing with one another, the question becomes, can you still share commissions? Of course, you can still share commissions. How do you go about doing that? The easiest way that we found, and we've designed a form to do this, and you'll see it in the Realcomp form banks, is an agreement called co-broker cooperation and compensation agreement. And the document is designed to meet the requirements of the settlement agreement. It's a document that is to be signed. It sets forth how commissions are being paid, who's paying them, and how they're being shared between the seller broker and the buyer broker. And it requires this particular form that we prepared on behalf of Realcomp. It requires that the seller sign this document so there can be no confusion. You sit down with your seller, you say, I'm going to take a commission of X%. I think in order to attract buyers, I'm going to have to share my commission with the buyer broker. Here's the document that I'm going to do it through. Here's all of the terms and conditions on how I'm going to do it. And then you can take this document and you can sit down with a buyer broker and you can say, look, I've got my seller to agree to a fee sharing agreement, if you will. This is how it's going to work. This is what I'm offering. The buyer broker can sign it, and then you have a full and functioning contract over fees and over commissions. Of course, this is just one way of doing it. There are other forms available. I think some of the other people that are providing forms, some of the big brokerage offices and some of the state offices are preparing similar documents. So there are other ways to do this. And of course, there's nothing that requires seller brokers to offer compensation to buyer brokers. That's not required, but it's not prohibited. And so business can still be done in a way that you've been used to doing it over the last many years since the MLS has been, an online functioning service. Of course, as I said earlier, some of this goes back to the way business was done in the 1980s and the 1990s when I was a young lawyer and giving advice in the real estate industry. There was no MLS online. There was no internet. And so people did business the way that we're describing it being done now. So in some ways it's back to the future or back to the beginning. So MLS participants must disclose to protect prospective sellers and buyers that brokerage compensation is not set by law and is fully negotiable. I've said that multiple times. This language has to be included in conspicuous language in the listing agreement and in the buyer written agreement and in any pre-closing disclosure documents. We must conspicuously disclose in writing to sellers and obtain sellers' authority for any payments or offers of payments that the listing participant or seller will make to another broker or agent. Again, I just went through that. And the best document to do that, as far as I'm concerned, is the document that I just went over. The next thing that's important is this buyer written agreement. And this was a big change. A lot of buyer brokers were not doing this in the years gone by. But when you think about it, a written agreement between you and your buyer is best practice. You're the agent of a principal in that situation, just as you're the agent of a principal in the selling situation. And the principal gives the authority to the agent to act in a particular way or in a particular manner. And it's good to have, as an agent, those directives in writing so that there's no dispute between you and your principal. Lawyers, in the 1980s, we did not regularly get retainer agreements. As time went on and as the world became more complicated and more sophisticated, lawyers now almost 90 to 100% of the time have a written retainer agreement. And as I said, when I began practice, written retainer agreements were very unusual. In the 1980s, we used to send out a bill that said, for professional services rendered in connection with your closing, including writing letters, reviewing documents, attending the closing, $2,000. And in the 1980s, that was acceptable. That's the way you did business. Now we're having to break down our bills by the 10th of an hour or the 20th of the hour. And the business is just being done differently. So I think this is best practice to have a buyer broker agreement. It'll set forth in writing what your obligations are, what you're entitled to. The important thing is that this agreement needs to be in place between you and your buyer before you show the first home. That does not mean that you can't later amend this agreement. This agreement can be amended. If you decide when you're going out with your buyer that you're going to do one thing, but as time goes on, it turns out that you're doing other things, go back and get the agreement amended. Enter into a new agreement, do an amendment, just make sure that it's in writing and that it's signed and dated. So, not to beat a dead horse, but these are the agreements, the listing agreements that you'll see in the Realcomp form bank. Brokerage commissions are not set by law and are fully negotiable. It's in boldface and in a darker and larger type so that it complies with the settlement agreement. We have also inserted provisions that allow you to, we'll get to questions at the end. We've also inserted methodologies for you to be creative in how your compensation is going to work. I've put a sentence here at the end. The parties understand, acknowledge, and agree that the foregoing agreement on compensation is objectively ascertainable and not open-ended. This is also a requirement of the settlement agreement. So if you come up with some kind of creative commission sharing arrangement, you can, or commission receiving arrangement, you can put it in the other section, but make sure that it can be understood by someone who might be looking at this later on, by a jury or another agent, or if there's a dispute, a judge. Make sure that your commission arrangement is understandable. We've prepared a number of documents that I've talked about a little bit. We've prepared a co-broker cooperation and compensation agreement. It's a very important document. If you don't use it, at least look at it and become familiar with it. And you can create something like that of your own. You can look at one of the larger brokerage agreements, one of the MAR documents. There are some things like it out there, but I think this is a very important agreement for you to be familiar with. We've prepared a limited service listing agreement. We've prepared a exclusive right to sell or lease contract. We've prepared a purchaser agency agreement, designated agency, a purchaser agency agreement, traditional, and an MLS entry only contract. We recently added a vacant land purchase agreement, and I've been promising, and I'm going to finally deliver to Karen soon, a commercial real estate agreement and a commercial lease agreement that you will be able to use as well and put me out of business by using my forms. So I think we've gone through these forms. The ones that are affected the most are, of course, the listing agreements and the co-broker cooperation and compensation agreement. We're going to get into the concessions discussion a little bit, and Karen's going to go through that. But before I say that, there was a lot of discussion about us adding pre-concession fields to the MLS system, and MLSs across the country went back and forth over this. It quickly became apparent in California, of course, and I mean that because they're sort of the leading edge of much of the industry, and they're also under the most scrutiny because of that. In California, there was some pre-concession fields that were added. People immediately began using those to convey offers of compensation. The Justice Department and the plaintiffs' lawyers were immediately on that. And so California cut out their pre-concession fields. And as a result of that, we decided that we wouldn't go forward with some of the plans that we had on pre-concession fields. There are still concession fields that you can enter post-closing. I think it's important to do that. And Karen will talk about how that works.
I am confident that you have, at least most of you have seen these changes that we had to make. I'm going to look at the big screen here with you. When you are reporting a property as a closed sale, one of the questions is, are there closing concessions? That's no different than what you had before. You were already being asked that question before. But now it's going to ask a little more detail. And one of the reasons we did this is we heard from a lot of our appraiser customers that said, hey, we could use some help with this stuff. We need some more details of this information. So we're asking a number of new questions. The concession closing costs, the concessions for, and that means is your seller contributing to the buyer's closing costs? Are there concessions for property improvement, new roof, new driveway? Professional fees, perhaps some attorney fees. And it tells you right there, other than broker commissions. And then concessions other, whatever other you may have. Once you have filled those in, it will total it for you. If you don't want to include the details, you can just put the total. But I've been asked to ask you to please put the details, because that information is very important when using these properties for comps. And then any comments that you may have. Let me just move on here. Okay. This is just a picture of what the profile or the listing change form looks like, where you fill in the sold information and now it asks you for those fields. So it's the same information as you saw on the previous screen, but this is just the written form of what that will look like. And then here's what you'll see on the listing itself. My favorite part is the blah, blah, blah at the bottom. So up at top is what you used to see. That's where it shows the how much was the compensation that was being offered. Now what you'll see are, and there was a field up there for compensation arrangements. That was used for, is it a dual commission variable, those kinds of things. That has been removed. But we did leave listing exemption. And that means, does maybe your seller had somebody that they showed their own house to several times and they want them to be excluded from the agreement. And that's where you would say yes, if that's the case, that there is a listing exemption. And then under that, you'll see where it will show you, are there seller's concessions? Yes. And then you'll get to put the blah, blah, blah part. And then over on the side is where you would enter, where you have entered those fields previously. This is where they'll show on the listing. It will be at the bottom. This particular example doesn't break down those concessions, but it does give you the bottom line. Okay, you're back. You're back.
So really, let me summarize what the major requirements are. And then we could talk a little bit about where the industry is going. And then I think the most important part is the Q&A. Hopefully you have some experiences to share, and we can talk about what this is like in practice, because it's easy to talk about it in theory. We sat down in our law firm and struggled with how the document should look and how the form should look and how we should make the documents and things comply with the law, the new law. And we're excited and interested to hear what all of you are experiencing, so that we can maybe make additions, improvements, upgrades, and invent new documents that'll help you in your practices. The 5 or 6 things that are important to remember are the following. The MLS must not be used to make offers of compensation. That's number one. We can't use the MLS to do that. We can't try to find ways around that. We have to be sure that both the buyers and the sellers, our customers and clients, know that commissions are fully negotiable and are not set by law. We must make sure not to tell them that our services are free. When we're putting together a commission arrangement, we have to make sure that the commission is objectively ascertainable and not open-ended. That means that a normal person, a regular person, has to be able to understand how you're going to get paid. You must have a buyer agreement before you show your buyer the first home. It does not mean that it cannot be changed or amended. If you say you're going to work for $500 because you thought you were going to show one home, and then it turns out that this buyer is going to have you work for months and months, you can change your agreement, and it can be a commission-based agreement. It can be a flat fee. It can be any kind of other fee that's understandable. But you must have a buyer agreement before you show your buyer the first home. And the seller must agree on how commissions are going to be shared, if commissions are going to be shared out of seller proceeds. And there are a number of ways to do that. As I said, it can be a document that you create. It can be a document that's available through your broker. It can be a document that is available through Realcomp. But those are the 5 or 6 things that are the most important. If you can remember those things, you'll be able to comply with the settlement agreement. So, open questions for the real estate industry. Excuse me. Already, the clear cooperation policy, since the settlement, the clear cooperation policy that NAR promulgated in 2020 is now the rule that's under scrutiny. So the DOJ is not going to leave the real estate industry alone. NAR thought that they had a settlement with the DOJ. This is sort of breaking news. It's been going on in the last several months. NAR thought that they had a settlement with the DOJ over a number of these policies. The settlement was virtually negotiated and implemented. And NAR, in fact, tried to argue that it was a final settlement. It turned out that the DOJ did not think that it was. The Court of Appeals has agreed with the DOJ that it wasn't a final settlement, and NAR has appealed that Court of Appeals decision to the Supreme Court. So the Supreme Court may weigh in on this in 2025. So the DOJ and FTC investigations are ongoing. There are still out there pending lawsuits that allege billions of dollars in damages over buyers having paid too high of commissions as a result of the NAR rules. Those claims are a little more attenuated. A lot of industry people think that they're covered by the Morrill and Sitzer settlement, but it's not a sure thing, and those lawsuits are still pending. What is the future of NAR? What will happen with NAR? There's a lot of hard feelings over NAR and some of these rules and regulations that have arose as a result of some NAR activity. But NAR has done a lot of good over the years for the industry. They certainly think that they're an advocate for the industry, and whether or not they go away is up to debate. Should non-realtors be allowed, non-capital R realtors be allowed to participate in the MLS? This is a nationwide sort of look and push for maybe greater participation by non-capital R realtors in MLS access. Will there be other structures to MLSs? Are there going to be new competitors? A lot of you have seen how Zillow has changed the industry. Some of it's been good. I think some of it's been bad. Will there be new structures yet to arise? And then what is going to be the effects of these new rules on all of you, on licensed professionals? Our commission is going to go down. NAR and some of the defendants argued very vociferously during the Sitzer and Morrill cases that these rules were designed to make the industry more competitive, and therefore were not designed to keep commissions unduly high. Those arguments did not carry the weight of the day, but I think there are some reasons to believe that some of the rules that have been promulgated have been designed to create competition. But it'll be interesting to see how commissions are going to be affected going forward across the industry. One of the things that the plaintiffs set forth in their arguments in Sitzer was that commissions in almost every other country that have similar real estate industries are much lower than the sort of the 6%. So sort of, I'll say standard. I don't think it was really standard, but sort of the 6% commission. In most other countries, those commissions are a lot lower than that. So that was one of the things that the judge and the jury found very compelling in the Sitzer and Morrill cases. So there's some question on what will happen with the licensed professionals. I think my own opinion is that everybody that's doing it full time and doing it well and practicing with all the best practices will continue to be able to earn a good living in the real estate industry.